Rule 112. Preliminary Investigation. Section 1. Preliminary investigation defined when required. Preliminary investigation is an inquiry or procedure there is an sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Except as provided in Section 7 of this rule, a preliminary investigation is required to be conducted before the filing of complaint or information for an offense, where the penalty prescribed by law is at least 4 years, 2 months, and 1 day, without regard to the fine. Section 2. Officers authorized to conduct preliminary investigation. The following may conduct preliminary investigation. A. Provincial or city prosecution and their assistants. B. Judges of the municipal trial courts and municipal circuit trial courts. C. National and regional state prosecutor. And D. An other officer as may be authorized by law. Their authority to conduct preliminary investigation shall include all crimes cognizable by the proper court in their respective territorial jurisdiction. Section 3. Procedure. The following investigation shall following manner. A. The complaint shall state the address of the respondent and shall be accompanied by the affidavits of the complainant and his witnesses as well as other supporting documents to establish probable cause. This shall be in such a number of copies as there are respondents, plus 2 copies for official file. The affidavits shall be subscribed and sworn to before any prosecutor or government official authorized to minister oath, or in their absence or unavailability before a notary public, each of whom certify that he personally examined the affiants and that he is satisfied that they voluntarily executed and understood their affidavits. B. Within 10 days after the filing of the complaint, the investigating officer shall either dismiss it if he finds no ground to continue with the investigation, or issue a subpoena to the respondent attaching to it a copy of the complaint and its supporting affidavits and documents. The respondent shall have the right to examine the complainant, which he may not be furnished, and to copy them with his expense. If the evidence is voluminous, the complainant may be required to specify those which he intends to present against the respondent, and these shall be made available for examination or copying by the respondent of his expense. Object as evidence need not be furnished a party, but shall be made available for examination, copying, or photographing at the expense of the requesting party. C. Within 10 days from receipt of the subpoena with the complaint and supporting affidavits and documents, the respondent shall submit his counter affidavits and that of his witnesses and other supporting documents replied upon of his defense. A counter affidavit shall be subscribed and sworn to and certified as provided in paragraph A of his section, with copies thereof furnished by him to the complainant. The respondent shall not be allowed to file a motion to dismiss counter. B. D. If the respondent cannot be suspended, does not submit counter affidavits within the 10 days period, the investigating office shall resolve the complaint based on the evidence presented by the complainant. E. The investigating officer may sit a hearing if there are facts and issues to be clarified from a party or witnesses. The parties can be presented at the hearing but without the right to examine or cross-examine. They may, however, submit to the investigating officer questions which may be asked to the party or witness concerned. The hearing shall be within 10 days from submission of the counter affidavits and other documents or from the expiration of the period of their submission. It shall be terminated within 5 days. F. Within 10 days after the investigating officer shall determine whether or not there is sufficient ground to hold the respondent for trial.